they so badly desire, I'm afraid, to transform American society that they endanger politicizing all issues, even the courts. In doing so, they are hopefully unaware that they are risking the very moral authority of the law. And that ultimately is what gives the law its power. The essence of the crossroads we face is to be found in President Obama's so-called empathy standard, a standard he has reaffirmed repeatedly and identified as the core criterion he has in filling vacancies on the federal bench. According to the President, the, quote, critical ingredient, close quote, for judges is the, quote, depth and breadth of their empathy, as well as their, quote, broader vision of what America should be. This is a stunning declaration, I think. To those of us who've dedicated our professional lives to the law, this standard stings the ears. Under the President's standard, the Constitution is no longer, I would suggest, the supreme law of the land. Instead, each court, allowing empathy to be its, to control, becomes a constitutional convention unto itself, controlled by the judge's own personal vision for societal change and political transformation. So this is what I call the siren call of activism. Under this standard, the historic judicial oath that judges take, quote, to administer justice without respect to persons, to, quote, do equal right to the poor and the rich, and to act, quote, faithfully and impartially under the Constitution and laws of the United States, is replaced by a new approach. This new approach frees this lifetime appointed, unaccountable politically, judge from the restraints of impartiality and constitutional justice and permits them to evolve the law to achieve their desired outcome. In short, the empathy standard is a politically new but carefully chosen code word for the old and brazen form of judicial activism this society has done so much to resist. Consider the words of Justice Sonia Sotomayor, who President Obama proudly announced he selected using the empathy criteria. In her speeches, she repeatedly said that it was right and natural that a judge's, quote, opinions, sympathies, and prejudices, close quote, would influence their decision-making and for their personal experiences to affect the facts a judge chooses to see. In other words, judges should not weigh the scales of justice with a blindfold objectively, but rather with their fingers pressed on the scales. And this is the fatal flaw of empathy. Empathy for one party can only be prejudice against the other. Is that justice? Is that consistent with the great ideals of American law? So if we follow the road paved by the empathy standard, if we abandon the legacy of objective jurisprudence rooted firmly in the Constitution and our legal heritage, we risk losing not only our magnificent legal system, but the very liberties our founders built that system to protect. The founders created a court system that was to be independent, impartial, restrained. All judges must be committed to these ideals if they're fit to serve on the bench. As Alexander Hamilton noted, courts cannot fairly judge laws if they have a hand in making them, nor can they be counted on to curb the excesses of power if they share in it. Today, we see that Alexander Hamilton's fears were not unfounded. Even as the President nominates activists to the bench, judges are now setting national policy based on their views, I think. We've already seen judges declaring that the words "under God" be removed from the Pledge of Allegiance and barring students from even a silent prayer at school. Yet we have, I'd note, a paid chaplain at the Senate that prays at each one of our sessions. Judges have dismissed the people's right to their property, saying the government can take a person's home for the purpose of developing a private shopping center so the city can collect more tax revenue. Judges have cited foreign laws, world opinion, and a United Nations resolution to determine what the United States Constitution says about a state law. The Constitution passed in 1789. To regulate global warming, the court found that the definition of a pollutant in the Clean Air Act of 1970, before global warming was a gleam in somebody's eye, now they've held it includes the clean, naturally occurring carbon dioxide plant food as a pollutant. And this has some real effect. The effect is to give the EPA huge power over our economy, a power Congress would never have given in 1970 and wouldn't vote for today. And in a case with important ramifications for our national security, 5 Supreme Court justices reversed a long string of precedents to hold that foreign enemy combatants had a right to challenge their military detention in U.S. courts. And, of course, there are more examples. Well, 2 paths lie ahead. One path leads to a rejuvenation of America's great legal heritage, a reaffirmation of the values of objective, impartial justice, and a renewed commitment to the legal principles on which our way of life depends. The other path leads us to a rejection of those values and principles and a continued slide to a postmodern society, a brave new world where words and facts no longer have real meaning. When words are bereft of meaning, no right, no liberty is safe. And where the greatest political document ever created, our Constitution, is thereby undermined, where politics rules every corner of the government, and where a legacy of American exceptionalism won through the toil and sacrifice of American heroes in every generation slowly slips away. The question before us is this: do we preserve our heritage of law and justice for our children, or do we allow it to erode on our watch? We are in a long and difficult fight, and these are the stakes. We must put the debate squarely to the American people. And we can take comfort in knowing that they are on our side consistently. We've seen it time and again. Even Justice Sotomayor was quick to distance herself from her activist record and prior statements and the empathy standard announced by the president who selected her. Why? Because under the cold light of day, I think she knew her prior statements could not be defended as an operable judicial philosophy. It will not hold up. The American people want judges who follow the law, not make it, who put principle before politics, who put the evidence before their empathy, and who put what the Constitution says before what they wish it said. Simply put, Americans want judges in the mold envisioned by Alexander Hamilton, not David Hamilton. Yet the president, any president, is entitled to a degree of deference regarding his nominees, and most of his nominees will undoubtedly be accepted, and most will be, I'm sure, able to handle the job on the bench. But I also believe that deference extends only as far as the nominee is committed and faithful to the Constitution and laws of this country. The laws and Constitution they're sworn to uphold. Some say our concerns are exaggerated and imaginary. I don't think so. I cannot and will not allow the easy confirmation of an individual who seeks a lifetime appointment to use that power of office to advance their own social or political agenda. I cannot and will not cast my vote in favor of a judge who will put his own prejudices and politics on a higher mantle than the law, the facts, and objective truth. I cannot and will not stand idly by as the Senate confirms a nominee that will use their authority to diminish rather than defend the Constitution of this great republic.